Before starting, I would like to please request all of you, the participants, to write your team codes in the chat box and with the roles you are playing in this round, so that we can move ahead. And I request all the participants to switch on their videos so that it can be visible. I request Council 46 to switch on camera. Thank you, participants. A lawyer's time and advice are his stock in trade. A lawyer has a duty to give his client the best possible advice without regards for his own financial circumstances. With these beautiful lines, I would like to welcome everyone to the much awaited round of the first virtual international client counseling competition 2023 by Mediate Guru in collaboration with the Luthra of law offices in India. I want to start by congratulating two teams for reaching the finals of this competition and wish you all a very best of luck. And I also want to thank all the esteemed judges for their valuable time to judge this proceeding. It's time. My name is Parasnath Mishra and I'll be moderating this session. But before we move ahead, here are some good general guidelines which the participants need to follow. So each team, the participants will get total of 60 minutes. Those 60 minutes will be divided into three parts. The first one will be, to begin with, first 45 minutes will be the client consultation period, which means the participants are expected to extract the relevant information, make legal for its resolution, decide the fees of the case, and satisfy the client. In addition, next 10 minutes will be post-consultation period. The advocates have to talk about their tactics, what they should do for clients, and what document they need from their clients, etc. This is where judges will see the mindset, planning, and skill of the counseling of advocate. It is at the discretion of the team to decide who will speak what and about their roles. Furthermore, next 5 minutes are for judges so that they can ask questions from the teams. It's completely discretion of the esteemed judges to either ask question or not. Now, this is the time to introduce you all with our esteemed judges for this much awaited event of this virtual client counseling competition 2023. Our first judge is Mr. Shantanu Jindal. Sir is a partner at JSA Associates and Solicitors. His practice covers diverse areas of general corporate, mergers and acquisitions, and private equity investment. He has been representing multinational companies in various cross-border transactions, advising on foreign direct investment, outbound the investment, joint ventures, technology transfers, and commercial contract issues. His work experience includes advising Indian and foreign parties on private equity investment in India and on various areas out of the Exchange Control Laws, Companies Act, and sector-specific laws. He has special interest in niche areas of pharmaceuticals and medical devices and has assisted clients in some of the very prominent deals in the past. Prior to joining JSA, he had experience of practicing before the Honorable Supreme Court of India and the Honorable High Court of Delhi High Court. It's an absolute honor to have you today with us. Thank you. Our next judge is Dr. Ashu Dhimanna. She is currently working as an assistant professor at Vivekananda School of Law and Legal Studies, WIPS, situated in New Delhi and affiliated to Guru Gobind Singh Indraprasth University. She has her expertise in criminal law, business and family laws. She also has a deep interest and stake in alternative dispute industry, as the increasing scope of ADR is bringing speedy justice to the needy. Ma'am is also elected Chief Advisor at MediateGuru's Global Advisory Board for the tenure 21-23, where she regularly gives her valuable advice and consultation to the partners and associates in the firm and stay actively involved in the operation of the firm. Our next and final judge for this session is Mr. Sitesh Mukherjee. He has 30 years of experience in conducting a variety of corporate commercial arbitrations, as well as regulatory dispute in diverse industries such as telecom, power and infrastructure. He also has significant experience in banking and financial related disputes. He has been trained and certified as a certified mediator from the Chartered Institute of Arbitrators, London, and Stroud Institute of Dispute Resolution, California. He's a member of the task force of ICC Commission on International Arbitration of Fraud and Corruption Related Dispute. He's a founding member of the International Arbitration and Mediation Center, Hyderabad, and also honorary CEO. Previously, he headed the dispute practices group at Trilegal, a leading law firm in India. He also served on the board of Trilegal. He is recognized in Chambers and Partners 500 and ACL profiles. He has been featured on as one of the India's top 15 dispute lawyers 2019 by the Asian Legal Business India. He was selected as the Dispute Management Lawyer of the Year at the Index Legal Awards. Thank you so much, sir, for giving your valuable time for us today. Thank you so much. Unfortunately, our other judges could not join us due to some difficulties. So I would once again like to extend the gratitude of the Mediate Guru towards the respected judges, and with their due permission, we shall begin the proceeding. Sir, ma'am, can we start this proceeding?
Yes, please. Thank you, Paras.
Thank you, ma'am. Now it's time for the proceeding. Please, you have the floor.
Pleasant evening to everyone across the screen. My name is Sanjana Reddy. You could refer to me as Sanjana. And I'm accompanied here today with my co-counsel, Nivedita. Both of us here are present here today to assist you in today's client counseling session. We'd ideally love to do this in person over a cup of coffee and some cookies in our chambers, but we're physically separated, yet virtually connected through our screens. So let's hope that this doesn't become a limiting factor and we can make the most of this session. This is our first meeting, I presume. So we'll try and keep this short for about 50-55 minutes. And also let's hope that we don't get to face any network issues. My preferred pronouns are she or her. Both the clients could introduce yourself, tell us how you'd want us to refer to you as and your preferred pronouns. We'll try ensuring that we keep the legal nitty-gritties to the minimum so that we have an effective and a fruitful discussion today. Whoever wants to start, whenever you're ready.
Good evening, Sanjana and Nivedita. Thank you for having us here today. And I'm Manik Bottlewala, and with me I have my brother, Ronak Bottlewala. You can refer to me as Manik.
Good morning, good afternoon, counsels, Nivedita and Sanjana. I am Ronak Bottlewala, a partner at the Bottlewala Law Firm. You can address me by my first name, that is Mr. Ronak.
Thank you, both the clients. Before we start our session, I just want to ask you how you found out about us and why you chose to approach us.
We found out about your firm through a family friend, and since we have heard very good things about you, we thought we'll approach you.
Thank you.
I concur with my brother's opinion here that we found out through a family friend, and we are here to resolve our partnership from the dispute, and we are not aware of the legalities and all. So we want some legal guidance from you, counsel.
Thank you both of you for your response. Okay, so since we're meeting for the first time, I'd also want to give you a brief background about both the counsels here today and our firm. So our firm essentially practices in civil and commercial law, and both Nivedita and I are experienced in negotiating disputes in this area for a while now. So we thought it'd be best for both of you if we understood your concerns thoroughly. And I would also like to know if you had consulted any advocates before us.
No.
Yeah, this is the first time we are visiting a firm of solicitors.
Okay, then we're good to start, but I think I will quickly canvas over how this session is going to pan out and what you could expect from us. So we have a couple of housekeeping formalities to go over, which Nivedita is going to continue. Nivedita, if you want to carry on.
Yes, please. Firstly, I'd like to welcome Mr. Manik and Mr. Ronak to this session. I hope that together with my co-counsel and I, we reach a mutually satisfactory response for the both of you. Proceeding, I understand that we have 45 minutes, like my co-counsel said. Do you have any time restrictions yourself?
No.
That's great. So I also understand this is your first time visiting in a client counseling session. So I will begin by laying out a brief structure of the interview in order to help you understand the process. After you tell us your problem, we will give you an initial assessment of what we think your position is, and we will conclude by advising you about the most viable courses of actions that are available to you. Both of us during this session would be asking follow-up questions. So at if any point during the interview you have any questions, please feel free to stop us. Now, like my co-counsel had stated, there are certain administrative items that I would like to take care of. Coming to the first aspect of it, I would like to tell you about our fee structure. At our firm, the fee cost of initial consultation is rupees 1,500. However, in case you decide to consult with us in the future, rupees 1,000 would be charged per consultation session. We'd also like to mention that we have a financial assistance program wherein you can get a fee cut or a pro bono assistance if you cannot afford our fee. We'd like to clarify, Mr. Manik and Mr. Ronak, that your interests and expectations of us are what matters, and money is just a secondary concern to us. Is everything clear till now?
Yes, definitely.
Great. Now, I would like to talk about the most important aspect of all, the confidentiality agreement. You may have already signed a non-disclosure agreement that our secretary had shared with you prior to the meeting. I'll just, in continuance of it, I'll just explain to you briefly what this privilege is and how it works. We'd like to tell you that we follow strict rules relating to attorney-client privilege. Whatever is said within this meeting would be strictly confidential. We are bound by law to not divulge your information to any third party without your consent. Be assured that the notes we take during these sessions are also confidential. And since we're doing this virtually, I would like to assure you that the link is also secure. We hope this sets your mind at rest.
Yeah.
Now my co-counsel would be dealing with the conflict of interest aspect. Over to you, co-counsel.
Thank you, Nivedita, for laying down the ground so beautifully. I just want to run you guys through the conflict of check and what exactly it means. So it's important for the client's best interest that we assess any potential conflict of interest that we might have. This essentially means that we have to see that we do not represent the client seeking relief against any of our previous clients. So in the course of the session, if you mention names of parties and if we sense a conflict of interest, we will immediately stop you there and let you know. But in case you wish, we could direct you to other advocates as well. So in order for both of us as client and counsel to approach the issue better, we would ask you certain questions at multiple intervals to assess the problem to the best of our understanding. And I can't emphasize this enough. I just want to reiterate what my co-counsel has just mentioned, which is that please be as open and as candid as you can so that we can advise you better, and be rest assured that everything that you share is going to be within the bounds of this virtual meeting itself. And should you wish to continue with us further, which you are at an entire liberty to do so or not, you may be required to sign a retainer based on your case, but that's again something that you can take a call on after the session. I hope all of this has fit in well. And if you have no further questions, we could start off. And I believe that you've informed my secretary that you had certain issues pertaining to your firm, Bottlewala and Brother. So would you want to elaborate on that? Tell us what brings you here. Whoever wants to start.
So I think I should begin. Uh, so I am Ronak Bottlewala. I and my elder brother Manik Bottlewala were partners in equal rights in our firm, Bottlewala and Brothers. This firm was established by our father, beloved father, late Shri K.K. Bottlewala, in 1972. Our father started this business with the vision of introducing cafe culture in tier B cities of Sindhya, starting with the city of Nagpur in Maharashtra. Presently, our chain of cafes is spread across 16 states and 49 cities, including major tourist spots such as Kairpur, Gorakhpur, etc. I agreed with the vision of my father, that is to create safe family spaces while strictly excluding liquor bars because I saw profitability in this business model initially. We were making profits till March 2020 when the pandemic hit. During the pandemic, we decided not to lay off our employees as they have been with us for a long time now and tried paying everyone with whatever money we had. Uh, the same led to dilution of our 60% of our personal assets, but we do not, wish to lose our employees only because we had a dilution. So that does not matter for us. The only reason I included this business model wherein uh, we included hookah bars and liquor bars in our firm uh, was just to make profits after the losses that we had incurred during the pandemic period, which also affected our family income overall. So, when my brother confronted me about the same in the heat of the moment, I did say that I and Jinwala have major share in the firm. Jinwala is a partner to our firm, third partner to our firm. Uh, so I did say that we have a major share, so we can take decisions for the firm. But I did not in any way have the intent to hurt the feelings of my brother, as I know that he has put in a lot of effort, time in this business to reach greater heights. Furthermore, it was only due to plethora of changes brought about in this due to this model that I forgot to inform my brother about the change, the recent transactions wherein we bought some accessories which are required for the business model to run. So now, if I move on to talk about the recent notices that we have received from the nearby housing societies. So we are located in nearby housing societies. We take on lease the land wherein wherein there are families situated, so that obviously we have to create a family space, safe family space. So we have to be located near these families, near these housing societies. So I think when we brought about this change in the business model, and I think when any business model takes up a change uh, around the world, there are certain obstacles and hurdles faced by that firm, uh, but I think that they are to be resolved by only discussing out things, sitting in a meeting and planning out a plan of action, so that we can overcome these obstacles and hurdles as soon as possible. But my but I don't think that the only solution left is to leave the firm or to throw an asset of the firm out of the firm and to dilute his assets completely. I think where my brother thought that he should start afresh, I do not agree with his opinion there. And I think we should discuss some measures wherein we can continue the business. I myself propose to limit the liquor and hookah bar model to certain cafes which are located in a marketplace away from the residential and commercial spaces, so that we can continue to make profits and recover from the losses that we faced. So as I said, I completely disagree with my brother's thoughts wherein he wished to completely start afresh. And as we know, we need his expertise and supervision now. I would also like to highlight the importance of Kruger Jinwala here. Mr. Jinwala has been like a family member to us. We trust him to the fullest extent, and we both opine that he is an asset to the firm because he is fully aware of our business running strategies and he can exploit the cafe resources to its fullest extent to make our business profitable again. I also think that this was the only reason behind giving him the, giving him the power to run the show in the cafe, to manage all the fairs, and wherein after that, after giving him this role, we assume the role of supervision. So yeah, that's all. And lastly, I would like to say that I am not at all in favor of straining my relationship with my brother and going into litigation cases, going into court cases, and disrupting my family relations. But I do wish to make profit out of this business, and I can discuss it out with my brother. Wherein we can, as I said, plan out an action plan, and we can, incorporate his measures, his thoughts in that plan, and as well as my and Mr. Kruger Jinwala's thoughts. So that's all, counsels, and I wish that you also guide us here so that we can, okay, we can, we are not bounded with any law so as to we are not able to make profits. So you can guide us about the legalities and all. So yeah, that's all. Now I would like to shift the podium to my brother.
Thank you,
Thank you for
Ronak.
that.
But yeah, before I start, I'd really like to thank both the councils for laying out all the legalities and assuring us of the confidentiality of it. And before I start with the facts, I think my brother covered most of it. But so I'll just add certain things that I think he missed out. First of all, when our father set up these chain of cafes, he strictly believed that they should be family friendly and child friendly. And on an evening, a family comes out, spends quality time, and goes back with with happy memories. But eventually, after the pandemic hit, like my brother said, we hit some losses and we had to dilute 60% of our collective personal assets, which again is not favorable to any party. But as businessmen, we have to see ups and downs, right? And post the pandemic, we wanted to recoup and we wanted to make our profits back. And like my brother said, Mr. Kruger Jinwala is an invaluable asset, no questions about it. He was the manager before, and he proved extensively well that his managerial abilities are really good, and which is why we offered him 20% stake in our partnership. Before, my brother and I had 50% each. Now, after induction of Mr. Jinwala, it became 40, 40, and 60, 40, 40, and 20. So after Mr. Jinwala was inducted, both of us, my brother and I, we took a step back and we were like, anyway, he is a very good manager. So why not let him run the show and we'll just be supervisory partners. And unfortunately, to my, to my surprise and my shock, once when I was checking the books of accounts sometime in October, I saw some irregularities. I saw some payments done towards, liquor and tobacco equipment. And I was completely shocked because being a partner, I thought somewhere along the line I would be consulted or I would know about it. But sadly, I was never informed of it by my brother or Mr. Jinwala. And I felt completely, left out and appalled that I was not even part of this decision. And second, my brother and I both, we were brought up in such a way where our father taught us that, alcohol and liquor, tobacco, whatever it is, it's very immoral and it's detrimental to the family structure. But again, it shocked me that my brother completely forgot about it just for the sake of money. I understand, even I'm a businessman, that profits and making money is very important to our business and to keep our business running, but I would want to do it in a healthy manner without going into ways of liquor and tobacco. We can diversify our business, make our profits in other ways, maybe bringing up restaurants or bakeries, something like that, but not alcohol and tobacco. That was something I'm completely against. And second is that I can't stress that enough, that it was done without my consent. I understand that my brother had his reasons, that he was keeping the best possible interest of our firm. But again, I don't think morals are something that are to be compromised for that. And I understand that I was also thinking of leaving the firm, but that is not something I want to go ahead with now because of my economic constraints, and I don't want to strain any relationship between my brother and I. So that's not something I want to go ahead with. And I'm very much interested in keeping both of our relationships, smooth and proper going further. And so which is why we're here. I myself have certain problems that I need specific solutions to. First would be definitely to reduce Mr. Jinwala's ownership. I'm not saying completely expel him, but at least reduce his ownership. Second would be to go back to our previous business model where we completely exclude liquor and tobacco, maybe phase it out, but that's not something I'm comfortable continuing in the future. And third would be to, of course, continue the business with my brother and I having equal share so that it does not have any effect on our familial relationship either. So coming back to the point where we started receiving notices from housing societies, that really puts me in a position where I can't choose because, like my brother said, both of us, we lease the property from 10 to 15 years from lessors. And because of these increased complaints, I'm very apprehensive that our lease may get cancelled. The lessor might not continue the lease to us, and that because most of our properties are in residential areas, I think that is something that really needs to be looked into, which is why I'm really apprehensive and would like that we gain some solutions and some clarity and puts our mind at ease after the end of the session.
Thank you, both
Thanks.
clients.
Yeah.
First of all, I would really appreciate the fact that both of you have been very forthcoming and you shared an issue that's been a deep part of your life in the recent past. If it's okay, I think a lot has been said. Just so that there's symmetry of information, I just want to recap. So it's both the brothers, Manik and Ronak, who have 40% equity each in the firm. And I presume it's a partnership firm. You could correct me if I'm wrong. And 20% equity is borne by Mr. Jinwala. And we're trying to chalk out how we go back to the previous pre-existing model, how do we dilute the ownership that Mr. Jinwala has in the company, in the firm, I'm sorry. Thank you for this. If my co-counsel would want to add, and I could continue. But before that, I just want to mention that at this juncture, I see that the troubled relationships between the brothers can be salvaged on multiple fronts. And I see that it's not just a fiduciary relationship that both of you share. There's also this human element that is involved, which is that the morals and the values that your father believed in is what you collectively want to uphold. And that's also one of our concerns that we will necessarily have to take into account. If Nivedita wants to add to this.
Yes. Let me begin by saying that we understand that you're in a very distressing situation right now, given that you had already incurred losses, and after that, there has been a change in the business model. It has raised some issues between the two of you as partners and as brothers. So we empathize with you, and we hope to bring out a solution that is in both of your favors. And I just have certain clarification questions, if I may ask them before you would like to add anything. Thank you for that.
Sure. So please go ahead. Yes.
Yeah. Firstly, you had told that yours is a partnership firm, right? Has it been registered?
Yes, the firm has been registered.
All right. And just to reiterate, your shares, the share percentages are you and your brother both hold 40% each, and Mr. Jinwala has 20% each. And this dilution of personal assets that had happened of 60%, was it prior to Mr. Jinwala's admission as a partner, or was it after his admission?
So it was prior to his admission. When the pandemic hit us, we decided not to lay off our employees, and due to that, our 60% of our personal assets got diluted.
Okay, and you had stated, Mr. Ronak, that after the change in the business model, there has been some profits that your firm has seen. So, is there any raise in the profit margin, or has there been a constant growth of profit, if any? Or Mr. Manik had said that there has been a loss in the families that have attended the cafe now because of the change in the business model. So, has there been a profit or a loss? If you could just enlighten us on that.
So I guess we are regaining back from the COVID times, and there is. I would not say that there are huge profits made out of this business model, but yes, we are coming back into the picture. We are, we are touching our, initial, business and business profits, and before that we had before COVID. So we are trying to touch those figures again, and that takes a lot of time in any business model. So next, if my
Absolutely.
brother has to add something to it, he can do so.
Yeah, I understand that it takes a lot of time, and right now, as of at the present, we don't see any booming profits. But due to the end of the pandemic, or at least subsiding of the pandemic, the business has been doing better. But personally, I wouldn't attribute that to alcohol or tobacco. Yeah, that's about it.
Okay. And Mr. Ronak, if I may ask you, since you've changed your business model to an alcohol and a tobacco-friendly cafes, so have you obtained any license from the respective authorities?
Yes, after I and Jinwala decided to go with this business model, Mr. Jinwala took care of all the paperwork. We obtained a license, and rest of the paperwork was, done by Mr. Jinwala. He had completed all the formalities, legal formalities, before starting off with this business model.
Okay, thanks for that. Thanks for clarifying that, Mr. Ronak. My co-counsel, if you want to add on to this, please. Yeah.
I'd like to intervene at this point. Thank you, both the clients, for answering the previous questions. I think both of you seem to mention a very interesting aspect, which is profits and commerciability. You want revenue coming in some way or the other. Let me tell you that alcohol and hookah or selling tobacco in your restaurants and cafes may not necessarily be the only way in which you could get money coming in. There can be other commercially viable options. I think Manik has talked about diversifying. That can be one of the many avenues into which you can see revenue coming in. You could probably tie up with food delivery agents, for instance, Swiggy and Zomato. That could, again, bring in a lot of money as well. Instead of you resorting to selling alcohol and hookah, you could probably increase your takeout options, because we all realize that the pandemic has hit us very bad, and we're trying to find ways to recoup money and find a way to live with it. So I think, how about you even explore the option of entering into franchisee agreements? What franchisee agreements do is it gives you a lot of initial franchisee fees that's going to be paid to you. So there's, again, money that's available for the firm and both of you, so that you could collectively take better options. What this does is that it leaves you at a greater bargaining point, and then you can decide on what your future future nature of business can really be like. Now, the intent behind why I'm telling you all of these commercial options is that you know that there are multiple other ways of running restaurants and cafes in the way you do, than merely only resorting to alcohol and selling hookah. But I think I have a couple of questions to this, if that's all right. One, I think Manik and also Ronak, they've mentioned that you have seen some irregularities in the audit reports that were undertaken by Mr. Jinwala. Could you please tell us what is the nature of those irregularities? Were they tax frauds, or were they just payments being made to procure accessories that can be used to sell alcohol in the market?
Yeah, the irregularities I've mentioned, they were related to procuring, procuring elements which are in respect of selling or procuring liquor and tobacco. Thank you for the solutions. They really put my mind at ease with respect to, increasing our profits. But I just want to focus this particular meeting about reducing Mr. Jinwala's share and, probably amending our partnership deed, because that's not something either my brother and I are familiar with, because it's a lot of legal jargons and both of us aren't familiar with that. So if you could throw some light on that, I think that would really help us out.
So, Manik, you mentioned partnership deed. So, if you're aware of this, could you please let us know if there's an exit clause or an escape route that's been mentioned in the partnership deed? It's all right if you're not aware of it, you could send us the deed and we could take a look at it. But is there something that you know of already?
Unfortunately, there's no such clause because this was a family business just between my brother and I and my father. So we did not think it would come, a day would come where we have to use such a clause. So we did not put that. However, I would be happy to send across the deed so that you both could have a better look at it and give us more solutions.
We appreciate that, Mr. Manik. And just to add on to my counselor's question, you had stated that you would also be open to diluting Mr. Jinwala's share rather than expelling him as a partner. So is there a dilution clause in the partnership deed that you're aware of? Because deeds usually have that as well. And it's completely all right if you do not know. We review the deed for you.
Unfortunately, I'm not aware.
Okay, that's all right, Mr. Manik. And just to, like my co-counsel had suggested, you do have other modes of commercializing your business, but even you are open to phasing out going back to the previous business model. So, and since both you and Mr. Ronak are agreeing to that aspect of it, I would like to give you certain non-legal remedies from that side of the aspect as well. So you could probably hire security guards for the time being to avoid any kerfuffles happening near your cafes so that there aren't any societal issues. And you may issue a disclaimer or a notice of some sort wherein you absolve your partnership firm from any liabilities that are caused by the customers that come. And Mr. Manik, you had said that there were notices that your firm had received. So do you have any idea of the nature of such notices? Was it are these complaints attributed to the actions of your consumers in detail, or does it have something to do with other things?
No, it was just with respect to how our customers were behaving in a very uncivilized manner in residential areas. So because the residents started feeling unsafe in their own homes, we started receiving notices of such kind.
Okay, noted. And yeah, since both of you are agreeing to phasing out this, and personally, I suggest for you to not expel Mr. Jinwala, although ultimately it is completely your decision. I agree with it. But given that he's been a part of your firm for a long time and he has been responsible for bringing up the profits, and you trust him as well, and he holds a great expertise. So we wouldn't want to put a strain on that relationship as well. So if you end up expelling him, there might be bad blood between the two of you. So you can, of course, dilute his share after we review your partnership deed and see if that's a viable option. Or you might also come into a compensation settlement with him wherein you agree how to repay him rather than in shares, which is also possible. But highlighting that since you do not have an expulsion clause in your partnership deed, which of course we will review and confirm, but unfortunately, without an expulsion clause in your partnership deed, expelling a partner is not possible according to the law. However, there are ways to go about it, which we can discuss in the future meetings. If you are open to it, Mr. Jinwala can also be a part of these sessions so that we can understand the relationship between the three of you, and we aim to resolve the firm issues as well as your issues. Co-counsel, if you want to pitch in.
Yeah, sure. I think I'd echo with your thoughts in this. But I just want to add in a couple of points without necessarily confusing you with a lot of legalese. I just want to run you through a couple of provisions in the Indian Partnership Act that really governs the unique situation that we're put in. It's multiple provisions in the Act lay out how all the partners together are bound to carry out the business of the firm at the greatest common advantage. And it's a duty that's imposed on all of them to be just and faithful to each other, and also render true accounts of the expenses that they make or the money that's been received by the firm. So all of these clearly haven't been met. So these can really be points where you can penalize Mr. Jinwala. And there's also a provision for indemnification of losses that's been caused due to the fraud that's been committed by any of the partners. So that can also be a viable option to penalize Mr. Jinwala. But clearly here we're not really looking at penalizing or taking this matter to court and litigating it. But these are other possible avenues that can really be there if things go entirely south. I would also like to mention at this point that we've referred to the idea of dilution of shares a couple of times now. We could explain to you how dilution of shares really works. It essentially means that whatever stake that Mr. Jinwala holds in the firm right now can be reduced by either bringing in more partners or reducing the or giving out more shares, so that the proportion that Mr. Jinwala holds as a stake in your company can reduce, so that both of you become the majority partners in this issue. Now, there are multiple ways in which we can do this. We could definitely park this discussion for a later date when we reconvene in the next couple of sessions. All we're trying to do is basically to assure both of you that there are definitely multiple other ways to explore and get to the most ideal solution that both of you are looking for. Is there something that Nivedita you would want to
Yes.
question or chip in? Yeah.
Yeah, I would just like to add on to what my co-counsel had said. Since we're talking about the legal aspect of it, under the Partnership Act, Mr. Jinwala is also required to get the consent of Mr. Ronak and Mr. Manik when changing the business model. And since that has not been done in this case, that's also an aspect wherein you can penalize him. Of course, like we had discussed, that is something that we would be dealing with when the time comes and if the time comes. And moving forward, if the two of you do not have any further questions, we would just like to quickly discuss the further remedies that you may have in the course of action.
I just have a small question, Ronak. I think you can go after that. My only question is, what are the clauses that you would suggest that we put in our partnership deed so that, going further, there is no ambiguity or there are no conflicts later on?
Absolutely.
Thank you, Mr. Manik, for the question. I'd probably take this, Nivedita, if that's all right. So we'd ensure when we sit for the next couple of discussions that we issue a fresh partnership deed with a new PSR, which is a profit sharing ratio. So what this does is that we'll try and make sure that the deed is ironclad so that it plugs in all the possible loopholes that we can see. For instance, there should be a mention of a statement of control as to what will happen if there's a change in sort of if the minority partners want to exit or if they commit certain fraud or undertake certain activities that are detrimental to the firm, what would happen in such instances? There could be other provisions like the clawback clauses, or there could be exit clauses, the expulsion clauses, or dilution clauses, like my co-counsel has rightly mentioned. I think there are multiple other clauses that we are going to help you with and make sure that they're a part of the new partnership deed with the new PSR. So I think that addresses your concern. If Mr. Ronak has something else for us.
So personally, I do not have a question. The councils, guided us well, and also gave us some options wherein we can use those options to make our business prosper. But herein, I would just like to, highlight what I think that phasing out, as said by Sanjana or Nivedita, I'm not so sure. As said by the council, that phasing out should be an option. So that option, I think, is currently, the best of my opinion. And I think that phasing out can also, help the business take a, stable stance after the pandemic. And, then we can move on to diversify our business to other avenues. And because I think that liquor and hookah bars uh, is currently going on in the Gen Z generation. And this was one of the reasons why I thought that this could lead us to, multiple profits. And as we have our centers at various nearby various housing societies, so when the family gatherings happen there, we witness teenage and Gen Z generation, you know, uh, also we witness them there. And I think this is one sector wherein where we thought that we should plug in, and we can provide them with these liquor and hookah bars. So phasing out, I think, should be an option until we reach a certain level, and then we can move on to diversify, if that's okay with my brother, and if the councils think that this is a good option to go for. That's all.
Certainly. Thank you very much again, both of you. We clearly have moved ahead pretty much. And I think we're also settled to an amicable solution. I think I see that both of you agree that you will continue to be a part of the firm, which is a great thing. It's and by also upholding the values that your fathers believed in. And I'm sure that you also respect the reputation that your firm has, and it's been in business for a while now. And I think you also have these reputational concerns and confidentiality issues. So I'd really suggest we could sit down, have an informal meeting, which I'd like to call a mediation or a negotiation session, when all the stakeholders can actually sit down and talk out your issues, so that we wouldn't necessarily have to escalate this into a litigation battle. We have multiple other ways of doing this. Like I said, a mediation or a negotiation session could really help with this. You could discuss how the PSR is going to be like. What these forums usually do is that they provide you with that private environment where you can resolve your issues, discuss things out, and it helps you sit down and talk about your problems in a way that you haven't been able to so far. And there's definitely going to be people like us, a mediator is going to mediate your concerns, but it's definitely going to be a client driven and run process in a very confidential environment, so that we come out with some mutually beneficial solutions here as well. Nivedita, would you like to add to this? Is there something that you're
please.
thinking about? Yeah.
Yeah. So, like my co-counselor has rightly suggested, we are here to advise you in the best possible manner. And given that we can all agree that both of you want what is best for the business ultimately, and what is best for your relations here. And like my co-counselor has rightly suggested, ADR mechanisms is the way to go, according to me. We all can agree that the wheels of justice move slow, and litigation, of course, is a very acrimonious process. So ADR mechanisms like mediation, negotiation, and arbitration, if in case you do have a dispute resolution clause in the partnership deed, which we will review. And based on the method of dispute resolution that is provided in our partnership deed, of course, we can move forward. But ADR mechanisms are a better option as they are economically viable. And given that you're just recovering from the losses that you've incurred, this is a better option. And a third party is involved in these processes, but these are completely client driven, and they cannot impose a decision that you as clients do not like or agree. So that's always the way to go. Just to briefly make you understand as to what these processes are. Mediation is a process where a neutral intermediary, the mediator, helps you to reach a mutually satisfactory settlement, wherein negotiation involves exposing the common and the opposing interests of the parties involved, wherein you bargain to resolve as many issues as possible. I would just like to give you an estimated timeline so that you know which process you're choosing for. In case of arbitration, if in case your partnership deed has it, the timeline is generally to a year to 1.5 years. And in case of mediation, it's up to 5 months, 3 months, and 3 months to 5 months. And in case of negotiation, it is depending upon you or the representatives you choose. So it can be as short as a week or a month, and as long as however it goes through. And I could also provide you the estimated costs if that's something you're interested in.
I think
Absolutely. So
it is of our interest, and if you could guide us, how much will it cost us? As litigation costs us a lot. So, if these mechanisms are economical for us, we will surely go by them. And as you also discussed, we can, talk about our interests, talk about our, where the things we disagree, where we agree, and we can plan out a plan of action. So, as you can also suggest, what are the costs of these methods?
absolutely. In case of arbitration, it is the most expensive method of dispute resolution. There is a ceiling of 30 lakhs and it varies based on your dispute value, which of course we will ascertain in the upcoming meetings. And in case of mediation, it starts from around 1,500 per mediation session to 70,000. Then again, it is based on the value of your dispute and how many sessions you wish to choose. And in case of negotiation, like I had already said, it's the representatives that you choose and you as clients who would be negotiating. So it is completely upon your discretion to choose it. So if
Thank you so much for enlightening us on that. But I just had a small question as to what would you suggest at this stage for us? Because I'm not clearly able to differentiate between a mediation and a negotiation at this point. But you being in that field for a long time, I think you'd be a better person to judge.
Surely, Mr. Manik, we can do that. As your counsels, we would suggest the mediation process. Since you've already tried to sort out differences on your own, this is the time where you need a third neutral intermediary to figure out what is best solution that is available to you. And like I had already stated before, we could also make Mr. Jinwala a party to this mediation settlement, so that mediation proceedings, I'm sorry, so that all the three of you can pitch in your ideas for the firm and we can develop the firm in its fullest potential. If that
Yeah, I
answers
think
your question. Yes, please.
that's a good option to go for.
Thank you.
Before we conclude, okay.
I see that the time has run out. Thank you again, both the clients. I think it's been a fruitful discussion. We've come to some conclusion of sorts. We definitely see each other over a couple of more sessions, and then chalk out what our future course of action is going to be. I think we'd also be sending out a list of documents from our end as well. First of all, we'd be sending you a retainer agreement, which will ensure our continued engagement in your case. Then we'd also be sending out a copy of our confidential agreement that we spoke about a couple of minutes before this. We'd also be sending out our fee schedule agreement for you to sign as well, so that we can get started working on this issue right away. For the sake of brevity, we've also penned out our contact details to you. You could reach out to us whenever you'd want to. We'd be happy to address all your concerns. You could set up a meeting with us whenever the time is feasible for all of us. Thank you for your time for the session.
Thank you, both Mr. Ronak and Mr. Manik. We hope
I
to
think I can.
facilitating a fruitful relationship. Yes, please.
I think I can speak for the both of us, my brother and I, that we are really satisfied with this session. We came into the session with a cluttered mind. We were very confused as to how we could go further. But now, thanks to both of you, we have some clarity in our head. And I think going further, you can aid us better so that there is no problem at all in the future. So thank you again for facilitating this session, and I hope to see you soon.
Sorry to interrupt in between. So the client consultation period is over, and now it's the time for the post-consultation period. So now you have the floor.
Thank you.
Thank you again for guiding us. Lastly, I would just like to say we will be surely coming back to you again, connecting to you again, so that we can take our matters forward. Thank you.
Thank you very much. Looking forward for that. So Nivedita, how do you think this session went? I just have to add one thing. I think I should appreciate, and I'm really glad that I think both of them were not just candid, they were very forthcoming with respect to sharing details that also helped us gauge what the situation is. And then I think initially started out with like two conflicting, contradictory positions, but I think towards the end of the session, I think when we'd given them the reassurance of other commercially viable options, or the fact that Mr. Jinwala can still hold a stake in the firm with reduced stake with respect to diluting the ownership. I think they've agreed to it, and I think we've moved a long way. Something that we have to pat ourselves for as well.
Yeah, I mean,
We'll have to do some more preliminary research and come back and reconvene tomorrow, so that once we get all the deeds that they had to send to us, the partnership deed and like other statements that might be helpful for us, we could take a close look at this. And I think, like I'd already mentioned, we should try to aim to ensure that we draft a new partnership deed, which is to plug any sort of loopholes that might arise in the future. So I think we should work on that as well. What do you think?
yes, to begin with, I think though they were in a distressing situation, they have been very forthcoming with us. And even though there are certain strains on their family relationships, they moved past it for their business goals. And like you had rightly said, they came with conflicting opinions, and in the end, they were able to agree on phasing out the business, which ultimately is the best for the business, for the partnership firm as well. And yeah, I mean, we have to obviously create another partnership deed. We have to amend the existing one. I would just like to look into the object clause of it, since they had already changed the nature of the business model. That's something that we should take a look at. And if in case there's no expulsion clause or a dispute resolution clause, which at the moment is the most important. If in case a dispute resolution clause suggests litigation process, then I think even then we would end up having a mediation procedure only, given that it will fall under the purview of a commercial dispute, and under the Commercial Courts Act, pre-litigation mediation is mandatory for commercial disputes. So that is something that we can agree on. And yeah, I would also suggest the partners to include a preemptive rights clause if possible, so that if unfortunately, if the situation arises in a later stage, when diluting the shares, they could be given the first preference to buy back the shares. That is something that would work in their favor. And yes, other than that, I do agree with Mr. Manik, in fact, that his consent should have been taken before changing the business model. And even the provisions of Partnership Act, specifically Section 12, and several case laws have categorically stated the same, that the rights of the minority shareholder cannot be just ignored. Even for the benefits of the firm, even in good faith, that is not something that can be ignored. So we should hope that this doesn't happen again and make the partnership deed ironclad. Yes, other than that, I think the remedies that we gave were good to start with, till we do an additional research and unless and until we find out other courses of action. Do you think we could have applied an alternative approach instead?
I was going to say that I think the solution that we'd given them with respect to going to mediation, I think, was one of the most effective choices, and I think they seem pretty pleased with that as well. And I think I really hope that we don't get to take the litigation route, and they get to talk out their issues and then figure out how they're going to change the PSR as effectively as possible when all of them sit down. And like you said, I think it was Mr. Manik had definitely been faulted. He should have been given the notice when they're changing the nature of business. Like you said, Section 12 Clause C specifically talks about giving notice, and they also. I also presume that Mr. Manik did not ratify the decisions, which means that even that argument cannot really be taken, and neither was Jinwala given an authority, be it explicit or implicit. So I think these are a couple of points that we have to keep in mind as well. And when we're sitting to bargain with Mr. Jinwala, I think all in all, I'd really say that we did a good job today, but we must put our teams to work day tomorrow and then reconvene and figure out how we have to view the situation in the larger scheme of things.
Yes.
Thank you. See you tomorrow, I guess.
Yeah. Yes, and before that, I will ask our secretary to receive all the documents just to go about it, just to recheck again. It's the partnership deed, their financial statements to see the irregularities that Mr. Manik has pointed out, the license that they have obtained to go about their new business, and the notices and complaints, of course, that they have received from the societies, just to check that there's no unnecessary liability or litigation that we're leaving open to. Is there anything else other than this?
Not something that I can think of right now. I think you've pretty much covered all the agreements. We could definitely get back to them if we find something in the course of things, if we want them to give something to us.
Yes. And since we've written notes, I suggest that we summarize the notes and send it to them so that they have the time to go through the document along with Mr. Jinwala, or just the two of them, to grasp what has happened in this session. It must have been overwhelming for them to go through, to take in all this information at once. So should I send the summary to them, or would you be doing that?
Sure, I think we could compile it and then
Absolutely.
we'll take a look at it once, and then we could definitely send it to them and see their comments on it. That's
Alright.
a great idea. Yeah, we should do that.
Okay, then let's meet tomorrow.
Yeah, see you tomorrow. Thank you.
Thank you.
Now it's the time for the judges to ask questions from the participants. First of all, I would like to call Sitesh Mukherjee sir if any questions for the participants, you can ask from them.
I would like to, first of all, congratulate all the participants for the excellent performance. I had a question for Sanjana, and not really question, also sort of a input, that she in the end had a number of legal, had just discussed a number of legal aspects with regard to Manik's rights being violated. In course of the discussion with the clients, she probably, I wanted to ask her whether why she did not get into the legalities of the case that Manik had, and whether, he had a strong case, or whether Ronak, ought to have considered some of the legal rights that had been violated.
Yes, so surely. I think I mentioned these provisions when they were there as well, but I didn't really want